Juris Vodcast with Scott Pearce.
Securities law is one of the most difficult subjects on any law school curriculum, and it's one of the most technical and arcane areas of law that you can ever want to look into. It's also extremely important. Today, I report on a case decided by the United States Supreme Court, Stoneridge Investment Partners, LLC versus Scientific Atlanta, Incorporated, et al. The Stoneridge decision is a huge win for investment banks, accountants, and lawyers. It's a big loss for investors who lose money on stocks issued by companies that commit fraud. The facts are not subtle, and they're not in dispute. A cable TV company persuaded Scientific Atlanta and Motorola, two commercial sellers of cable TV boxes, to jack up their prices and then use the extra profit to buy advertising on the cable system. The cable TV company then reported the inflated price they paid as a capital expense and booked the advertising purchases as revenue. This allowed them to pretend to meet Wall Street's revenue expectations. When the cable TV company's true financial picture became known, its stock value collapsed. Plaintiff, a shareholder, Stoneridge Investment Partners, filed a lawsuit. The 5-3 U.S. Supreme Court decision held that plaintiffs must be able to show that they relied on the deceptive behind-the-scenes behavior of the defendants in making their decision to acquire or hold stock in order to have a cause of action. In the majority opinion, Justice Kennedy wrote that Section 10b does not reach all commercial transactions that are fraudulent and affect the price of a security in some attenuated way. It does not incorporate common law fraud into federal securities law. Writing for the dissent, Justice Stevens said that investors relied on defendants' revenue statements in deciding whether to invest, and in doing so, relied on the defendant's fraud, which was itself a deceptive practice prohibited by Section 10b of the Securities Exchange Act of 1934. One fascinating aspect of this case, from behind the scenes, is well worth considering. The Securities Exchange Commission supported the plaintiffs, but the Treasury Department supported the defendants. Treasury prevailed, and the SEC was denied authority to file a brief on the side of the plaintiffs. According to the New York Times, Justice Kennedy's majority opinion closely tracks the brief that Solicitor General Paul D. Clement eventually filed. This decision is the latest in a long string of cases that have limited private plaintiffs' rights to implied causes of action under Rule 10b-5. In this case, I find the reasoning of the dissent to be persuasive. It seems to me that the majority opinion is requiring an extra degree of causation that really shouldn't be required under the facts, particularly given the case precedents in play. You can find this case, as well as Central Bank of Denver versus First Interstate Bank of Denver from 1994, and Basic versus Levinson, a case from 1988, at jurisvodcast.com. Securities law is complicated, but it's interesting and important. I encourage you to look into these cases and to think carefully about how we regulate the securities markets. For jurisvodcast.com, this is Scott Pearce. Thanks for your attention.
Juris Vodcast is a production of Nuclear Podcasting. Creative Commons Attribution Non-Commercial, No Derivatives.